Hello everyone, this is Urvashi Chauhan and you are watching Courts Today by Livelaw, your one-step destination to all legal developments in the country. A landmark judgment has been delivered by the Supreme Court today. A constitution bench of the Supreme Court today held that it can invoke its special powers under Article 142 of the Constitution to grant divorce on the ground of irretrievable breakdown of marriage, which is not yet a statutorily recognized ground. Though the judgment refrained from laying down concrete factors to be considered to decide if a marriage has been irretrievably broken down or not, however, the judgment specified certain broad illustrative factors. For example, the period of time the parties cohabited after marriage, that the period of separation should be sufficiently long, the nature of allegations made by the parties against each other and their family members, whether and how many attempts were made to settle the disputes by intervention of the court or mediation, etc. In this case, the original issue actually referred to the Constitution bench was whether the mandatory waiting period for divorce by mutual consent as under Section 13B of Hindu Marriage Act HMA could be waived. As you must know, under Section 13B of the HMA, after filing the first motion seeking divorce through mutual consent, the parties have to wait for a minimum of 6 months and a maximum of 18 months before moving the second motion. This cooling off period, as it is generally called, is mandated to give the parties an opportunity for introspection and to rethink over the decision. However, this requirement for a waiting period was found to be causing hardships in certain cases. And today, the court held that this mandatory waiting can be dispensed with, subject to requirements and conditions laid down in the previous judgments. During the hearing, the bench further decided to consider the issue whether marriages could be dissolved on the ground of irretrievable breakdown. The court held that in exercise of its power under Article 142 of the Constitution, it has the discretion to dissolve the marriage on the ground of its irretrievable breakdown. This discretionary power is to be exercised to do complete justice to the parties. The Constitution bench, comprising Justices Sanjay Kishan Kaul, Sanjeev Khanna, A.S. Oak, Vikram Nath and J.K. Maheshwari, pronounced the significant verdict. Lastly, the bench also made it clear that a party cannot file a writ petition under Article 32 to seek relief of dissolution of marriage on the ground of irretrievable breakdown of marriage directly from it. This is a major development. To read the full judgment or summary with head notes, you can click on the link given or visit www.livelaw.in. In another important news, the Supreme Court of India today allowed the withdrawal of a petition which sought ban of political parties which use names and symbols with religious connotations. The plea had further sought strict enforcement of certain provisions of the Representation of People's Act, which prohibit luring of voters and promoting hatred between different classes of citizens on the basis of religion. The court was also informed that a copy of the similar petition had been filed before the Delhi High Court. A bench of Justices M.R. Shah and Asanuddin Amanullah was hearing a writ petition filed by Syed Wasim Rizvi, the former chairman of Uttar Pradesh Shia Central Board of Waqfs. He recently renounced Islam and converted to Hinduism with a new name, that is Jitendra Narayan Singh Tyagi. In September last year, a top court bench had issued notice in this matter and had asked the Election Commission of India to file its response. And the Commission had told the Supreme Court that there was no express statutory provision under the Representation of People's Act which barred the registration of political parties with names having religious connotations. The Supreme Court today pronounced an important judgment on default bail. The court held that an accused person would not be entitled to default bail on the ground that the charge sheet filed against him is without a sanction of valid authority and hence is an incomplete charge sheet. The judgment was pronounced by a bench comprising CJI D.Y. Chandrachud and Justice J.B. Pardiwala. For context, let me tell you here, Section 167 of CRPC provides for default bail. So if the investigation against an accused person is not completed within requisite time, he is entitled to bail by default. The rationale behind this provision is to ensure that the investigation is completed within the period prescribed. As per the provision, investigation should be completed within the first 24 hours. If the investigation is not completed, then it is to be transmitted to the magistrate, who considers whether the accused can be remanded to custody or not. In the present case, it was argued that even though the charge sheet was filed within the statutory prescribed period, it was filed without a sanction of valid authority. So the charge sheet was incomplete and was equal to not being filed within the requisite time. But the court rejected this argument and held whether the sanction of a valid authority for a charge sheet is required or not is not a question to be addressed while taking cognizance of an offence. Rather, this question is to be addressed during prosecution, and such prosecution starts after the cognizance of an offence is taken. To read the full article, click on the link given below. Another update coming from the Supreme Court, where a plea was filed challenging the Punjab and Haryana High Court's decision to completely prohibit access to hybrid hearings following the resumption of physical hearings. Today, the Supreme Court granted the petitioners the liberty to move the Chief Justice of Punjab and Haryana High Court to address the grievance on an administrative side. A bench comprising CJI D.Y. Chandrachud and Justice J.B. Pardewala said, since there has been a deployment of public funds for setting up the ICT infrastructure under the e-courts project, grievance of the petitioners can be suitably addressed by the Chief Justice of High Court of Punjab and Haryana. If you remember, in February this year, while hearing a plea seeking to declare virtual hearings a fundamental right, CJI D.Y. Chandrachud had expressed his anguish towards Chief Justices of High Court who have started disbanding the infrastructure for virtual hearings. CJI Chandrachud has been a strong advocate for the use of technology in the judiciary and has emphasized the importance of virtual hearings in promoting access to justice. The Supreme Court today agreed to hear on May 8th a petition filed challenging the decision of the Bihar government to prematurely release the former Bihar MP Anand Mohan in the case of mob lynching of District Magistrate G. Krishnaiah in 1994. G. Krishnaiah was killed after an attack by a mob which was led by Anand Mohan. He was sentenced to life imprisonment for the offence. However, he walked out of jail on April 24th this year after serving 14 years of imprisonment because of the remission of sentence granted by the Bihar government. The background is that as per the remission policy of the state of Bihar, persons who are convicted for murder of public servants on duty were not eligible for premature release until they have completed at least 20 years of sentence. However, this bar was taken away by the state government by amending the remission policy in April this year. So now, the persons convicted for murder of public servant on duty are eligible for remission without completing 20 years of sentence. The petition challenging this has been filed by Uma Krishnaiah, the widow of the deceased District Magistrate G. Krishnaiah. The petition states that amendment of the state remission policy to felicitate Mohan's release is contrary to public policy and would amount to demoralizing public servants. Today, the petitioner's counsel advocate Tanya Shri mentioned the petition before the Chief Justice of India for urgent listing, upon which the CJI agreed to list it on May 8th. Stay tuned for more updates on the case. And now coming to an update on the sedition law under Section 124A of the Indian Penal Code. The central government today informed the Supreme Court that it was in the process of re-examining Section 124A of IPC and that the said process was at an advanced stage. The submission was made by Attorney General for India R. Venkataramani before a bench comprising CJI D.Y. Chandrachud and Justice J.B. Pardewala while the bench was hearing pleas challenging the 152-year-old sedition law in the country. The petitioners also stated that the court had to decide if the matter was to be argued before a 7-judge bench because in Kedarnath versus State of Bihar, a 5-judge bench of the Supreme Court had upheld the validity of Section 124A. The Apex Court today decided to hear the matter in August this year. I would like to remind you here that in May 2022, the Supreme Court had held that Section 124A of the IPC should be effectively kept in abeyance, that is, in temporary suspension, till the Union government reconsiders the position. We will keep you updated with all progress in the matter. Coming to an update on the public interest litigation filed before the Supreme Court to direct the Law Commission of India to prepare a draft on anti-conversion law. The PIL filed by BJP leader Ashwini Upadhyay has also sought for a direction to the government to take steps to control forceful or fraudulent religious conversions with specific allegations against missionaries spreading Christianity in the state of Tamil Nadu. Responding to the PIL, the Tamil Nadu government has submitted that anti-conversion laws are prone to misuse against minorities. In the affidavit filed before the Supreme Court, the Tamil Nadu government has stated that people have the right to propagate and preach their religious belief to other persons, and people also have the choice to change their beliefs as long as it is without intimidation or deception. Calling it politically motivated, the Tamil Nadu government has pointed out that the PIL has been initiated with the intention of fueling religious intolerance against a particular faith. And now coming to an update on the Krishna Janmabhoomi case in Uttar Pradesh. The Allahabad High Court today directed a court in Mathura to decide the suit relating to the Shri Krishna Janmabhoomi Shahi Eidgah land dispute pending before it without being influenced by the observations made by the Mathura district judge on the merits or contentious issues of the case in its order dated 19th May 2022. Significantly, this order of the Allahabad High Court has paved the way for the resumption of hearings of the suit before the Mathura court seeking the removal of the Shahi Eidgah located adjacent to the Shri Krishna temple complex in Mathura and the transfer of 13.37 acre land to the deity Bhagwan Shri Krishna Virajman. Thank you for watching. If you wish to know more details about the cases I mentioned here, you can check the links given in the description box. Stay ahead with quick legal updates only on Live Law. Do not forget to like, share and subscribe and support us.